SJC-13071. Salvatore F. DiMasi, B. William F. Galvin, Secretary of the Commonwealth.
Okay, Attorney Green.
Good morning, Your Honors. May it please the Court, Assistant Attorney General Julie Green for the Secretary Galvin. Chapter 3, Section 45M was enacted as part of a sweeping reform of the public integrity statutes that was intended to restore public confidence in the legislative process by strengthening the laws relating to lobbying, ethics, and campaign finance. Section 45M furthers that purpose by preventing individuals convicted of certain felonies relating to the legislative process from acting as paid lobbyists for a period of 10 years. But the narrow construction given that statute by the Superior Court would undermine that purpose and deprive the people of Massachusetts of the substantial benefits provided by that statute by excluding from the statute serious criminal convictions for no other reason than that they were prosecuted in a different jurisdiction.
Why shouldn't we just look at the plain meaning of the statute and look at what the statute says and interpret that?
Because the statute is ambiguous. As the Superior Court itself recognized, the canons of statutory construction point in two opposing directions here. Either interpretation suffers from sort of unsatisfying elements. The Superior Court emphasized that the narrow reading has a significant problem, which is that it would entirely read out of the statute the reference to felonies in violation of Chapter 55, because there are no felonies under Chapter 55. That was true today. It's true today, and it was true also in 2009 when Section 45M was enacted. In fact, the best illustration of the very serious problem that that reading causes is the Superior Court's own discussion at page 10, page 69 of the addendum, where the Superior Court characterizes that problem as an even more absurd result than the result caused by the broader reading given by the Secretary, where it says...
I mean, it's clearly an error by the legislature, but does that also mean that if someone is convicted of bribery in Nebraska,
simply due to the happenstance that they were prosecuted by federal authorities or that the individual was, living in Nebraska at the time that they committed the bribery? I also want to...
Is that really a realistic appraisal of this when you read it as a whole? When you read the statute as a whole, we also have to take into account the Secretary had discretion previously, right? And they eliminated that, right?
That's correct.
And they don't reference the like offense language, and it's sort of consistently protective of legislators who get in trouble. It has a narrow reading. It's limited to the state statutes. It doesn't reference statutes in general. It removes the Secretary's discretion as before. I mean, it seems to be a pro-legislature, a convicted legislature statute, rather than a broadening. It's a narrow.
I want to make sure I understood the question. So correct me if I'm misunderstood.
Let me rephrase it a little bit. This seems to be consistently narrow. It removes the discretion of the Secretary that previously exists. It references only state statutes, not other statutes. And you can see that the legislature may be protective of its own here.
I would say there's no basis for a conclusion that the legislature was trying to be protective of convicted legislators. I think the opposite is true. Here's what I think we know from the legislative history. It was clear the legislature intended to remove discretion by making disqualification automatic upon a finding of a predicate conviction.
Right, but let me just push that point. They also narrowed. In the past, the secretary had almost unlimited discretion. Here they reference 3 particular state statutes.
Yes, but what they referenced were felonies in violation of 3 state statutes. And the question is how to make sense of that reference, where the narrow reading...
Is that even more protective of the legislature, because it's saying, I'm only going to disbar you for 10 years if you violate the felony provisions of these particular statutes. In certain ways, it's a sheep in wolf's clothing here, isn't it?
It's all that change tells us is that the legislature was not looking to penalize all felony convictions, regardless of whether they had anything to do with the legislative process or not. That was the earlier amendment that was proposed in the morning and rejected. Rather, the legislature was looking to penalize felonies that are related to the legislative process. And I think that's all that history can tell us.
But they're trying to take discretion out of the Secretary of State's hands, correct? When he or she prior to this had discretion. Would you agree with that?
I wouldn't agree with it in full. I think it was discretion as to what to do once a predicate violation was found, but they weren't...
Beforehand.
I think there are 2 steps to the analysis. Let me try to answer your question. There are 2 steps to the analysis: finding the predicate violation conviction, and then what result to impose. They were clearly trying to remove discretion at the second step. Once you find the conviction, you must disqualify. But that doesn't tell us that they were removing all human
now
interpretation.
They changed that to say, if there's a violation of these statutes, it's automatic. You don't get to pick and choose.
That's correct.
But when we have the situation where it's an out-of-state or federal violation, the Secretary of State, in essence, gets to pick and choose.
I disagree.
By making it a like offense, which you read into the statute.
I disagree.
All right, tell me why.
There's no pick, for 2 reasons. There's no picking and choosing as to what to do once the conviction is found.
Okay,
And
let's use my hypothetical Nebraska bribery case.
So then, in that case, there's no discretion as to, there's no discretion. What there is there's an act of analysis to compare the Nebraska elements of the crime with the state elements. So in this case...
So who does that?
That's done by the secretary. That's not discretion, though. That's an act of interpretation. It's a construction of law that is subject to judicial review and reversal if it's an erroneous interpretation of law. Very different from discretion.
That's certainly different from automatic, isn't it?
No, I disagree, because automatic refers to what the secretary does upon a legal conclusion that the 2 crimes are like or equivalent.
But whenever that happens in the rest of the criminal law, OUI is the prime example, or domestic violence, it's a like offense in SORB, right, sex offender cases as well, to sexual offenses. That's a process that they make the executive go through. Here we don't have that. Or you're reading it into the statute, essentially.
But I think that's implicit in the statute, and it's the only way, honestly, to make sense of the statute.
It's only implicit to the extent that the Chapter 55 felony provision is in there. That's what you're really hanging your hat on?
It's one of my 2 central arguments about ambiguity.
What's the other one?
And the other one is that it would that the narrow reading tends to defeat the purpose of the statute by excluding a whole swath of crimes where there's no evidence the legislature intended to exclude them.
Have we ever said the legislature just had a draft in error?
I think the court is forced to conclude that under either the narrow or the broad reading. Clearly, the reference if you give it the narrow reading urged by the Superior Court, found by the Superior Court, you have to conclude that the reference to felony is a drafting error. If you give it the broad reading urged by the Secretary.
Or the reference to Chapter 55 is the drafting error, because there are no felonies in 55.
That's right, that's possible. Alternatively, there's a drafting error, or at least an imprecision in the reference to only state statutes and not like convictions in other jurisdictions. What you have is two opposing, I mean, you have canons of statutory interpretation, each pushing in opposite directions. You clearly have problems in either construction.
Can I push back on that a little? The legislative history is important, and they didn't use the language about the equivalent federal or state crimes, and there's the issue of Chapter 55 and the felonies. But if we go back to the first question that Chief Justice Budd asked, what about just the language? I mean, do we have to go beyond just the language? The Secretary of State shall automatically disqualify any person convicted of what? Convicted of what? What do they say? Convicted of a felony in violation of Chapter 3, Chapter 55, or Chapter 268A. That's it. That's what they say. Why is it so hard to interpret that?
Because the interpretive process doesn't end with the simple language of the statute. I mean, the court has repeatedly said, and I think most obviously in the Montalvo decision cited in our reply brief, that the determination of whether a statute is ambiguous looks at the plain language, but also at the statute as a whole and at the statutory purpose.
However, we were able to juxtapose another section to make it absolutely clear that the plain language was wrong. When you juxtaposed it with another section, it was clear that it wasn't a mandatory minimum. Here, there's nothing to juxtapose this against. It's just saying violations of these specific felonies. End of story.
Well, let me give you a different answer, which is I think this court has repeatedly recognized implicitly that language just like this is susceptible both of narrow and broad readings. And here I'd point you to Kaleidos, in which the court labored hard to determine that that statute was penal, so the opposite of this situation. And from that, it concluded that it had to give similar language, a narrow construction limited only to the literal listed statutes. And this court has repeatedly confirmed 3 times that what Kaleidos did was it gave a narrow reading to that statute. So Bonomo, Gaffney, Bulger, the court said that was the narrow reading. Implicit, though, in the notion of a narrow reading is that a broader reading was possible. So that's our position here. Here, both a narrow and a broad reading are possible. And what pushes in the direction of a broad reading here is that the purpose is reform, not penalty, and that the Secretary was charged in the first instance. The legislature charged the Secretary as part of this reform package with interpretive power over the lobbying laws. And the Secretary's interpretation is reasonable in the face of ambiguity.
Okay, thank you.
Thank you very much.
Attorney Fierro.
Chief Justice Budd, and may it please the court, Meredith Fierro on behalf of the appellee. Your Honors, Section 45M means what it says.
Okay, let's talk about Chapter 55 in the felony. Does that make it ambiguous? And is it a drafting error, or do we give meaning to everything a statute says, and therefore it's ambiguous?
Chapter 55 was clearly, the reference was clearly an oversight by the legislature. That's the only realistic possibility.
Have we done that in our statutory interpretation?
We
have lots of cases where we say, well, we're kind of stuck. We have to give meaning to everything the legislature says. Have we ever said, well, this is just plainly wrong and a drafting error?
Yes. In Commonwealth versus Brown, 431 Mass 772, a 2000 case, the court said the problems with this amendment were simply the result of a legislative oversight, one we cannot remedy. We interpret that portion of the statute that applies to the offense before us in accord with the plain language the legislature used, in accord with similar provisions in other statutes. And it's important to remember, it's not this court's reading of Section 45M that makes the reference to Chapter 55 superfluous. It's just inapplicable because of that mistake by the legislature. There's no reason that the legislature would include that reference knowing that it contained only misdemeanors. So it's the only option is that it's an oversight. So the best reading of this statute that does not read words out of the statute or insert words into the statute and do violence to it, as the Secretary seeks to do, is simply to construe it according to its plain language. And if the legislature wants automatic disqualification to apply to misdemeanors in Chapter 55, it can amend the law. And what the Secretary is really attempting to do here in this case is to reclaim discretion the legislature took away by injecting ambiguity into an unambiguous statute. The statute specifically enumerates the 3 state laws that automatically trigger disqualification of a lobbyist for 10 years. And as was discussed with my sister, the statute does not contain the word conduct. It says nothing about like offenses. It doesn't reference the United States Code. It doesn't use the phrase violations of state or federal laws, which the legislature has used in other statutes. And it says nothing about public corruption crimes. And as this court
I agree with you on that. The question I have for you relates to the Attorney General's sort of bigger picture, which is, you know, the legislature characterized this as a reform designing to increase protections against this type of, you know, lobbying by convicted officials. But it seems like they did the opposite. They narrowed who's covered, and to such an extent, it's actually providing much less protection than the law before it.
Well, I think it makes sense that you can construe it in 2 ways. First, you can construe the legislature's action that the reason that they made disqualification triggered by violations of those 3 statutes is that those were the 3 statutes that the 2009 law legislation was aimed at reforming. I think it was called an act to improve the laws related to lobbying, campaign finance, and ethics. And by limiting automatic disqualification to those 3 laws, one could argue that they were encouraging prosecutions to be brought at the state level rather than the federal level. Another way of looking at it, as I think Your Honor may have alluded to, is one could look at it as having an element of political theater. But either way, this court's role is to construe the text according to how it's written and to effectuate legislative intent. And you don't look at legislative intent by the kind of in the broad way that the Secretary is asking you to do. You look at what did the legislature actually do, and they did narrow the law. Prior to 2009, the Secretary had broad discretion to disqualify anyone from registering as lobbyists for cause shown, very similar to conduct. And the legislature, when it reconsidered that law, removed that discretion, made disqualification automatic, and triggered by convictions under one of these 3 state statutes. So it's clear what the legislature was intending to do with this specific provision.
What they actually do is they essentially create a 10-year ban that only applies to 2 statutes and only felonies under those 2 statutes, substantially cutting back on the prior ban. You know, I understand that's maybe what they intended, but it is somewhat concerning that a statute that was meant to, you know, protect against this type of activity actually facilitated it.
Sure, Your Honor. I'm sorry.
But in context, they also completely overhauled and tightened the lobbying registration requirements and restrictions against lobbying, correct?
Correct, Your Honor. And they also increased the penalties for violations of the lobbying law from misdemeanors to felonies, and same with the ethics law.
That cuts against the restriction, the Trojan horse that's being argued here.
I mean, there's no requirement that we agree necessarily with what the legislature did. That's a policy judgment that's for the legislature. It's not for the secretary. And if the legislature decides that it's absurd, as the secretary contends, not to include federal convictions or convictions in other states, it can amend the law. And in fact, it recently considered doing just that. This past legislative session, Senator Becca Rausch filed a bill, Senate Bill 2110, titled An Act Closing the Loophole in the Lobbying Law, that would have extended automatic disqualification not just to felony convictions under Chapter 355 and 268A, but also to any person convicted of any other state or federal felony crime of political corruption, including without limitation violations of sections 1341, 1343, 1346, 1951 of Title 18 of the United States Code. So clearly the legislature knows how to use this language, again, when it intends to do so, and you know what happened to that legislation? It was sent to study. So I think we know what that means, and that tells us all we need to know about the legislature's intent in this regard. And it's not up to the secretary to reconsider that. It's not up to the secretary to act as a lawmaker and try to insert words into the statute regarding conduct that aren't there, and also read out words, such as the word automatically, which is not susceptible to multiple interpretations. It clearly means, it emphasizes that the secretary's task is ministerial, doesn't involve the exercise of his judgment or intent, and is something that, frankly, can be done by a computer. When an individual goes to register as a lobbyist, the only requirement is they put in their name, address, pay the filing fee, which is, if you're your sole proprietor, then you have to pay $1,100. And there could be a checkbox. Have you been convicted of a felony under Chapter 355 or 268A? Check the box under pains and penalties of perjury. You know, it would be complete. It's not this complicated task that the secretary is contending today. And I'll just, if there's no further questions, I'll just conclude by saying that, as this court stated in Jocelyn versus Chang, the principle of judicial restraint embodied in Article 30 of the Massachusetts Declaration of Rights recognizes the inability and undesirability of the judiciary substituting its notions of correct policy for that of the popularly elected legislature. If this court were to adopt the secretary's interpretation, it would be doing exactly that. So we ask the court to affirm the Superior Court's decision.